Morning, everyone. Welcome to the Virginia Gas and Oil Board hearings for December 16th, 2025. For everyone online, if you will please remain muted unless you're participating in the conversation. Everyone in attendance here in the room, please self mute. And if you need to take a call, please step out in the hallway because we are recording these proceedings today. This time I'll ask the board members who are present here today to introduce themselves. Starting with Mr. Owens.
Patrick Owens, public member, and Mr. Chairman, as you expect, I've got a received conflict with items 7 and 8 due to a relationship with the interested party company that I own.
Dennis Sutherland, co-representative.
My name is Gus Jansen. I'm a public member, also serving as the chairman of the board.
Willie Cochran, Virginia Energy member.
We do have a quorum present today with 4 members here. We do have some members who will be remote attendance. At this point in time, the board will approve any board member that will be attending remotely. Who do we have on the line so far? I'll go through them in order here. Do we have Mr. Mullins, Lawton Mullins available?
Yes, Lawton Mullins, industry representative. Mr. Chairman, I will be abstaining from items 7 and 8 as well due to a business relationship with the parties involved.
Do I have a motion from the board to approve remote attendance for Mr. Mullins?
I'll make that motion.
Do I have a second?
Second.
All those in favor, signify by saying aye.
Aye.
Any opposed? So Mr. Mullins is approved for remote attendance. Next on the list, do I have Mr. Harris on the line?
Yes, I am.
Okay. Do I have a motion for the resolution approving remote attendance for Mr. Harris?
Make that motion.
Do I have a second?
Second.
All those in favor say aye.
Aye.
Any opposed? Okay, Mr. Harris, you're approved for participation in today's board here.
Thank you. Let me just announce I'm a public member of the board.
Thank you. Ms. Gibson, do we have you on the line? Ms. Gibson, are you on the line? Are you muted, Ms. Gibson?
Yes,
Okay, you're all right. Okay. Do I have a motion from the board approving remote attendance for Ms. Gibson today?
Make that motion.
Do we have a second?
Second.
All those in favor, signify by saying aye.
Aye.
Aye. Any opposed? Ms. Gibson, you have approval to be remote attendance participation in today's hearing. If you're ready to introduce yourself.
it's Mayor Gibson.
And Ms. Gibson, you're a public member also, correct?
I'm sorry, I didn't get you. I didn't hear you.
You're also a public member of the board?
Yes, I
Yes.
am a public member of the board.
Thank you very much, Ms. Gibson. I think we have that procedure behind us. Item number 2 on the agenda today is the board will receive public comments. Don't think we have anybody sign up for public comment. If there's anyone in the audience who wishes to make a public comment, please come forward. Seeing none, we'll proceed. Item number 3 on the agenda today, the board will review and vote on renewal of the First Bank and Trust their escrow agent contract for the term of January 1, 2026 through December 31st of December 2026. I think everyone received the information regarding the contract and the renewal process for the escrow agent. I think this is this year 2 of a 10-year contract with First Bank and Trust? Is that correct? So this is a process we do every year. We have to approve our escrow agent. I think First Bank and Trust has done an exemplary job of handling their escrow account. If there's any other discussion from the board members on the renewal of the contract with First Bank and Trust as our escrow agent?
Mr. Chairman, I'll make a motion to approve.
Okay, do I have a second to approve First Bank and Trust?
Second.
Have a motion and a second. Ms. Gilman, you go ahead and hold the board since we have the online people now.
Yes.
Mr. Sutherland,
Yes.
Mr. Cochran,
Yes.
Mr. Harris,
Yes.
Mr. Mullins,
Yes.
Mrs. Gibson,
Yes.
and Mr. Jansen.
Yes. So that approves First Bank and Trust as their escrow agent for the next calendar year. You'll let the First Bank and Trust know that that's been taken care of. We'll continue on with business as usual. Item number 4 on the docket today is a petition from Key Rock Energy LLC for creation of a sealed gob unit and force pooling unit. Forest Bridge number 2, docket number VGOB 25-1118-4325. Ask that all parties who need to address this application to please come forward and identify themselves.
Tim Scott and Aaron Davis. Mr. Davis is going to be testifying remotely today.
Okay. Will you swear in the witness, please, Ms. Gilmer?
Mr. Davis, you swear or affirm that your testimony is the truth, the whole truth, and nothing but the truth?
Yes, I do.
You may begin, Mr. Scott.
Thank you, Mr. Chairman. Mr. Davis, please state your name, by whom you're employed, and your job description.
Name is Aaron Davis, employed by Key Rock Energy. I'm a senior engineer.
And you're familiar with this application before the board today?
Yes, I am.
And you helped prepare this application, is that correct?
That's correct.
And presently, or the unit configuration that we submitted with the board was for 423.66 acres, is that correct?
Yes.
And are there any parties respondent listed on Exhibit B3 that we're going to dismiss today?
No.
And how was notice of the hearing or this application provided to the parties listed on Exhibit B3?
By certified mail, return receipt requested.
Have you provided the proof of mailing to the board?
Yes.
And are there any unknown parties respondent in this unit?
Yes.
And how was notice affected for these parties?
By publication in the Dickinson Star, December 3rd, 2025.
And we have, as I indicated, and you just testified, we do have unknowns. Are you continuing your efforts to locate these individuals or parties?
Yes, we are.
Okay.
Yes.
And what track or tracks have unknown parties, and what's the percentage of each track within the unit?
Track 2 has 7.61%. Track 3 is 9.66%. Track 9 is 0.06%.
And we provide a proof of publication to the board, is that correct?
That's correct.
And there is no escrow requirement for this unit, is that correct?
Correct.
And EROC is authorized to transact business in the Commonwealth of Virginia, is that correct?
Yes.
And there's a bond on file with the department, is that also correct?
Yes, it is.
And you were able to reach an agreement with the parties listed on Exhibit B3, including those that you may later discover their identities. What terms would you offer?
It would be 12.5% of royalty.
Okay. And you consider that to be fair and reasonable for a lease in this area?
Yes.
And what percentage of the unit does Key Rock presently have under lease?
73.43%.
And what percentage are you seeking to pool today?
26.57%.
And requesting the board to pool these unleased parties, is that correct?
That is correct.
And that Key Rock be named as the operator for this unit, is that also correct?
Yes.
And if the board grants our application today and an order is entered with regard to this application, what would be the address used by any parties respondent making an election under that order?
Be 145 George Street, Suite D, Beckley, West Virginia, 25801.
And that would be the address for all communications for this unit or application, is that correct?
That's correct.
And Mr. Davis, you participated in preparation of the AFE, is that right?
That is correct.
So you're familiar with operations and well costs associated with this particular application, is that correct?
Yes,
What's the proposed well depth?
it is 475 feet,
And what are the estimated reserves for this unit?
700 MMCF.
And again, you did participate in the preparation of this application, is that correct?
That's correct.
And what's the estimated completed well cost?
$492,796.
Okay. And in your opinion, if the board grants our application today, would it prevent waste, promote conservation, and protect correlative rights?
Yes, it would.
Mr. Chairman, that's all I have for Mr. Davis.
Questions from the board?
What was that address again for the correspondence?
Yes, the address is 145 George Street, Suite D, Beckley, West Virginia. Zip code being 25801.
We do have a Johnson City address that's in there,
Yeah, you got a zipping address, yeah.
but it's for the notices or for any elections that are made, they go to Mr. Davis in the Beckley address. Okay,
So is that address part of the order?
I believe it is, yes, sir. If not, I'll revise it.
I just see the Johnson City address in the order that you provided.
Okay, I'll fix that and resubmit it.
Okay, Mr. Davis, just for clarification, you indicated the payment to a unleased party would be a 12.5% royalty. Could you expand on that? I know that this is a little different application where we're paying based on the carbon credits. Can you expand on that like we have in the past, just for clarification?
Sure. The gas that we collect and destroy on site is quantified on an annual basis. And that amount of gas is through computation to equivalent tons of carbon dioxide. Carbon credit offsets are issued and awarded by the California Air Resources Board, and those offsets are monetized. And that happens once a year, and that is the entirety of all the revenue that a site will produce. So from that, then the royalty would be 12.5%.
Okay. And that's paid basically once a year. Is that you've been your historical past, right? Rather than a monthly basis?
That is correct.
Okay.
Yes.
The other question I had is, I believe several of the applications we've had from Key Rock in the past that included a shut-in payment provision. I don't see that in this. Is that something we've done away with at this point?
Correct.
So you are requesting to do away with the shut-in payments? Okay.
Yes.
Any other questions from the board?
Mr. Chairman, let me ask a quick question. This is Bill Harris.
Yes, go ahead, Mr. Harris.
Okay, the recipients, if Key Rock gets their payment once a year, does that mean, and this may have been answered before, does that mean the recipients get their payment, their royalty payments once a year, or is that divided into monthly payments?
It is a lump sum once a year. Yes.
Okay, I was just curious. Thank you.
Any other questions from the board? Board operates on a motion. Do I have a motion for this petition?
Motion to approve.
Do I have a second?
A
I'll
second.
second.
Thank you. We have a motion and a second. Ms. Gilmore, will you poll the board?
Yeah.
Mr. Sutherland,
Yes.
Mr. Cochran,
Yes.
Mr. Harris,
Yes.
Mr. Mullins,
Yes.
Mrs. Gibson,
Yes.
and Mr. Jansen.
Yes. Thank you, Mr. Scott. You have approval of this?
Our order is subject to providing a correct address for,
Yes.
all right, I'll take care of that. Thank you.
Thank you for clarifying that. The next item on the agenda is a petition from Pocahontas Gas LLC for disbursement of escrow funds should who deposited with the board's escrow account. Attributed tracks 1D and a portion of 1F, 1H, and a portion of 1I and 1J is depicted in the annex table associated with several parties. This is an inactive unit producing under BUC 1 SGU 6 VGOB 23-0516-4263, unit W47, docket number VGOB 98-1117-0699-05. All parties who wish to speak to this petition, please come forward and identify yourselves.
Mark Swartz and Kelly Berry.
Thank you, Mr. Schwartz.
Mrs. Mayor, swear or affirm that your testimony is the truth, the whole truth, and nothing but the truth?
I do.
Okay, could you state your full name for us again, Kelly?
Kelly Berry.
Who do you work for?
I work for CNX Gas Company, appearing on behalf of their subsidiary Pocahontas Gas LLC.
Do you have a job title?
I'm Senior Analyst of Land Records, Division of Interest and Pooling.
This petition today is for disbursement from escrow, correct?
That's correct.
And also dismissal of several coal owners.
Yes.
And what unit are we talking about?
Unit W47.
It looks like this unit was initially pooled in 98.
That's correct.
Okay. The chairman indicated that this unit is currently inactive. Can you tell us about that?
Yes, the unit has been pooled as a part of Buchanan number 1 sealed gob unit 6. So the previously existing frac wells have been plugged, and this unit's ownership is now subject to the production from that sealed gob unit.
Okay. And that occurred, the sealed gob unit appears to have been created in 23.
That's correct.
Okay. And the factual basis for the relief that we're requesting, first of all, I think we have royalty split agreements.
Yes, we do.
And have you included those with your application toward the end?
Yes, we have.
And then in addition, we have a long list of people that are entitled to CBM royalties under the statute 45.2/1624, correct?
Correct.
And that's a process under that statute. We are required to give notice to coal owners who would have conflicting claims. Is that true?
Yes, that's true.
Did you do that?
This unit, I believe, was repooled, and so the coal owners were notified of their dismissal with the recorded board order for the unit when it was repooled.
Okay, and at paragraph D on page 3, you've reported that.
Yes.
Okay. And essentially the process under the statute is you give notice to coal owners who might have conflicting claims. They have a specific period of time to respond and offer evidence that would support a claim. And if they don't, they're dismissed, which is what happened here.
That's correct.
Okay. What did you do to notify people that we were going to have a hearing today?
We mailed a copy of the petition to each owner proposed to be paid by certified mail with return receipt requested.
And have you provided your certification with regard to that mailing to the division?
Yes, I have.
Okay. Do you want to add any respondents today?
No.
Do you want to dismiss any respondents today?
Yes, we have several owners who need to be removed due to failed mailing or notification that the owner was deceased.
Okay, and who are the people that we want, at least as of today, to remove as respondents for the reasons you've just expressed?
That would be Linda Collins, Melissa C. Keene, Taryn Dean Neville, George Felix, Doris Sue Smith, Max Smith, Sylvia Ann Smith, Margaret Snell, and Carrie Ziegfeld Schmidt. I've prepared revised exhibits reflecting those owners being removed from the Exhibit EE and placed back on the Exhibit E. And Ms. Gilmer is going to set this petition back for revisions after the hearing today so that I can update all of those owners on the table to remove them as well.
And at PDF page 9, we have a table 1, correct?
Yes,
Okay, and this is unlike what we usually see. This is not a percentage distribution. Is that true?
that's correct.
Okay, and why is that?
We are paying prior owners for their periods of ownership pursuant to the royalty split that was signed by the original owners, which were Larry and Dorothy Keene. The property has changed hands. Tract 1J has several times during the production period, and we're paying each owner their proportionate share of the escrowed funds based on their periods of ownership.
And in table 1, you have provided not only the names of the folks, but you've given current addresses. Is that correct?
Yes, I have.
Okay, and then in the far right-hand column, you've given a specific dollar amount for each of the people on table 1.
That's correct.
And is that the precise amount that the escrow agent should pay to the folks you've identified in table 1?
Yes, that is correct.
And should the timing of that payment, should that be made before the table 2 payments, which we'll be talking about in a moment, are made?
Yes, it should.
Okay. Because the balance needs to be adjusted before the percentage is applied.
That's correct.
Okay, let's go to the next page, which is table 2. And this is quite a long list. Let me get my screen here. And table 2 states at the beginning is a pay percentage.
Yes,
correct?
it is.
Okay.
Yes.
And we've talked about delaying that calculation until the dollar payments are made.
Yes.
And on this table 2, if we go to the far right-hand column, there we go. We have dollar amounts, but the escrow agent is not to use those amounts.
That's correct. They're to use the percentages in the third column from the right to
Okay.
calculate.
And this was an estimate of the dollars that would have been due at the time you prepared this exhibit, which may or may not exactly be the balance after the disbursements under table 1 are made.
That's correct.
Okay, so just to be clear, the board, or not the board, but the escrow agent should use the percentages in the third column from the right to calculate the dollar amount due each of the people you've identified in your table 2.
That's correct.
And in addition to identifying the folks or companies that should receive these payments, you've given what you believe to be a current address for everybody.
Yes.
Okay. And this goes on for quite some time because we're talking about a lot of people. And if we go to the end, which is PDF page number 16, you have again explained your deductions. You've got some comments, right?
Yes,
then,
regarding Tract 1J.
Okay, and then also, we're supposed to disclose the contributing wells, and you've done that.
Yes,
Okay. PDF page 17 is your Exhibit E. And is that what Exhibit E would look like, subject to, I take that, is that what Exhibit E would look like in terms of the escrow that needs to be maintained going forward, if this application is approved, bearing in mind that you're making some changes with regard to the list of respondents?
yes,
Okay, so the people that you're dismissing today will be removed from Exhibit E, at least temporarily.
yes,
Okay. And if we go to the very end of Exhibit E, which is the list of folks for which escrow is required, which is PDF page. I'm getting there.
36.
Okay. Yes, at the very end, PDF page 36, you've got a little section called total conflicts, correct?
Yes,
And acreage in unit and percentage of unit. Do these numbers represent the conflicts that remain and require escrow?
yes.
And the acres are how many acres?
5.3838, which is 6.7298%, which will be updated with the updated Exhibit E to include the owners who needed to be removed from the payment
Those percentages and acres should increase slightly.
slightly.
Okay. And then we've
Yes.
got exhibit double E, which is PDF page 37. And that exhibit will also need to be amended to account for the folks that we're removing from the list of respondents.
Yes,
Okay, but Exhibit E is intended to give sort of the roadmap going forward for everyone as to who the operator will be able to pay directly rather than putting their money into escrow.
yes,
If we go to the end of Exhibit double E, which is PDF page
64.
64. We've got total acreage that you've been able to resolve and pay people or be paying people if this is approved, and the percentage resolved. And what are the acres and what are the percentages?
71.3262 acres at 89.1577%.
And then the next page, PDF page 65, is the escrow reconciliation that you're required to do, correct?
That's correct.
Okay. And basically what you do is you take you account for all of the checks that the operator has paid to the escrow agent, and you make that list, right?
Yes,
And then you compare your list to the deposits shown in the escrow agent's records.
yes,
And that's what we've done here over several pages.
yes.
What does the highlighted yellow indicate?
The highlighted yellow indicates a discrepancy between the amount of our payments into the escrow account and what was shown on the escrow agent reporting.
Okay, and those are discrepancies that if we go to the very end, I think you indicate you have been unable to resolve those discrepancies.
Yes,
And then we've got, in addition to the highlights in yellow, we've got cells that are outlined in a darker black.
yes,
And in fact, we have an example of that on the first page of Exhibit J. What is that telling us?
That tells us that if you add together the payments that are in the darker black bracket, they equal a corresponding payment on the escrow royalty deposit side.
So
They
those
balance.
were actually apparent differences that you were able to resolve.
Yes,
Okay. And as we go through the document, there really aren't a lot of issues. It's just at the very beginning, right?
yes,
Okay. And if we get to the end of Exhibit J, which is PDF page 70, we've had prior disbursements.
yes, we have.
Okay. And then did you do a calculation to compare your estimate as to the balance to the First Bank and Trust balance and calculate the difference?
Yes, and the First Bank and Trust balance is $335.09 more than our balance.
And then the next page, and continuing on for quite a while, are copies of split agreements.
Yes,
Okay. And as we go through that, then we had, and you mentioned this one when we were first talking about the table 1 payments, but you've got an email here that you sent to Ms. Gilmer back in October. And it indicates that I think to summarize, that the e-form system does not really allow you to make the kind of changes you wanted to make, correct?
yes, eForms does not allow you to pay prior owners from multiple account dates that have different balances of acreage in escrow.
And this explains that problem, and the division is aware of it, and you've been able to work around it, at least as
Yes.
far as the e-filing goes. Okay. Then got more split agreements. And those take us, I think, to the very end, and they do. And I think that's all I have, Mr. Chairman, on this item.
Questions from the board? Just one question for clarification, Ms. Berry. On
Yes.
your exhibit EE, and I think the exhibit B3, there's some documentation pending on several of the track identification, some of the individuals there. Can you elaborate on what that means?
Sure, that means that we have found an owner to be deceased. We have requested documentation of their heirs from those who appear to be current owners, and we are awaiting return of that documentation.
Okay, so will the escrow agent be able to pay those people without that documentation, or how will that work?
No, we require recorded documentation of heirs in order to pay the individuals who are heirs of a deceased owner.
So are those parties not listed on the sheet up there for payment, or are they listed?
No,
They
they're
are not
not.
listed? Okay, so those people are still pending
yes,
additional information. You'll come back again sometime in the future if you get that documentation, correct?
yes, we will. Yes, sir.
Okay, thank you. Any other questions from the board? The board operates on a motion. Do I have a motion for this petition?
Motion approved.
Do I have a second?
Second.
We have a motion and a second. Will you please poll the board, Ms. Gilmer?
Mr. Owens,
Yes.
Sutherland,
Yes.
Mr. Cochran,
yeah,
Mr. Harris,
Yes,
Mr. Mullins,
yes,
Mrs. Gibson,
yes,
and Mr. Jensen.
Yes. You have approval for that application, Mr. Schwartz?
Thank you.
Pending the corrections to the petition that Ms. Berry has outlined.
Yes, sir.
Thank you. Next item on the agenda is a petition from Pocahontas Gas LLC for one, the disbursement of escrowed funds hereto deposited with the bank's escrow agent attributable to a portion of tracks 2G and 2I as depicted on the annex table. And number two, the authorization to begin paying royalties directly to Wanda Sue Roberts, Rogers Party Royalty LLC, White Wolf Energy LLC, and Richard E. Roberts, Unit X46. This is docket number VGOB 99-1214-0766-04. All parties who wish to speak to this application, please come forward and identify yourself, please.
Mark Swartz and Kelly Berry.
Thank you, Ms. Berry. Ms. Berry, you're still on oath, so you may begin, Mr. Schwartz.
Okay, you say your name for us again, please?
Kelly Berry.
And who do you work for?
I work for CNX Gas Company, appearing today on behalf of their subsidiary, Pocahontas Gas LLC.
It looks like this unit was pooled in 99.
Yes,
Okay, and again, it's another disbursement petition authorizing direct payment, hopefully, and I think this one we actually do have a couple of co-owners to dismiss.
yes,
Okay, it involves X46, correct?
yes, that's correct.
Okay, let's go to the factual basis for the relief requested, which is PDF page, I think, 2. And the reason we're making the request is what?
A portion of the disbursement will be based upon royalty split agreement, and the other portion will be based on House Bill 2058.
Okay, which is also known as 45.2/1624A, right?
That's correct.
Okay. Have you attached copies of the split agreements to the end?
Yes,
Okay. What did you do to notify people we were going to have a hearing today?
mailed a copy of the petition to each potential payee by certified mail with return receipt requested.
And provided certification with regard to that mailing and the people signing for or accepting the mailings to the division.
Yes,
Do you want to add any parties today?
no,
Do you want to dismiss anybody today?
no,
Or remove any respondents today?
no.
The next item we want to talk about is your table, which is PDF page 8, I think.
Yes,
And this is, we only have one table on this unit, and this is a percentage table. Is that correct?
that is correct.
Have you listed the names and addresses of everyone that we propose the escrow agent pay?
Yes,
And in making the payment, the escrow agent should apply the percentage in the second column from the right to the balance on hand at the time the payment is made to calculate the dollar amount of the check to be paid to each person who is receiving money.
that's correct.
Okay. And again, as required, we have provided an identification of the wells that contributed to or are contributing to this escrow account.
Yes,
Okay. Next item is Exhibit E, and this would reflect the people whose money is going to remain in escrow and whose potential money is going to continue to be paid into escrow going forward, even if this application is approved.
yes.
End of that, we've got what are the total acres in escrow and the total tract percentage in escrow.
The total to remain in escrow is 3.7159, and the total percentage is 4.6449.
Percentage is different than you just gave me, I think. No, hold on, I'm at the wrong page, hold on.
Page 14.
Gotcha, okay. Okay, correct. And then Exhibit EE is the roadmap going forward. That is whom you would be paying going forward if this application is approved.
That's correct.
And then we have an Exhibit J again, which
Yes.
starts at PDF page 28. And again, we have a couple of highlights in yellow. Remind us what that means.
That means there is a discrepancy between our records and the escrow agent records that
And
cannot
then
be resolved.
right, and then the highlighted in black, lower in the page, what does that represent?
Those represent payments that are reconcilable with each other by totaling them.
We've got some more yellow and some more outlines in black in the following page, correct?
Yes,
Okay. And continues to somewhat, but then obviously it gets cleared up at page PDF page 31 forward. We don't have any more differences.
that's correct.
Do we have prior disbursements?
Yes, we do.
Okay. And did you make a calculation? Well, first of all, did you make an estimate with regard to what your records would indicate the balance might be?
Yes,
And did you compare that to the October 25th First Bank and Trust balance?
yes.
And what did you determine?
The balance of the bank is $47.37 less than our balance.
And in general, is Exhibit J a comparison that you made by making a list of all of the checks that the operator sent to the escrow agents, because there have been more than several.
Yes.
And then you took the escrow agent records to the extent they were available and made a comparison, and that's how you determined whether there were discrepancies or whether you were in agreement.
That's correct.
Okay. And then starting at page 30, PDF page 34, we have a collection of split agreements, right?
Yes, there's
Or
one split
actually-
agreement. Yeah,
Actually, just one, right? Okay.
Yes.
And then you've got a supplemental affidavit of mailing at PDF page 37, your certification with regard to the mailing and when the mail was received at the next page, 38.
yes,
And that was actually your notice to the coal owners to step up to the plate and prove they had documentation of a claim,
yes,
and you received nothing.
that's correct.
And then you've got the green cards and a sample of the notice letter that you send. I
Yes.
think that's all I have, Mr. Chairman.
Questions from the board? Board operates on a motion. Do I have a motion on this petition?
Motion approved.
Have a motion? Do we have a second?
Second.
We have a motion and a second. Skip, will you please poll the board, please?
Yes.
Mr. Sutherland,
Yes.
Mr. Cochran,
Yes.
Mr. Harris,
Yes.
Mr. Mullins,
Yes.
Mrs. Gibson,
yes.
and Mr. Jansen.
Yes. Thank you, Mr. Schwartz. You have approval for this application.
Thank you, sir.
Thank you.
Okay, the next item on the agenda. The board will consider the petition for reconsideration submitted by Buchanan Energy Company LLC, which was continued from the November 2025 hearing. This time I ask all parties to please come forward who wish to address this item.
Thank you, Mr. Jansen. Tom Pruitt for Buchanan Energy. Representative of the company will not be testifying. Ms. Jason Davidson.
Okay,
here with me.
Mark Swartz for Pocahontas.
Okay, I'm going to try to summarize what we're going to do next, and I'll ask Ms. Cooper to jump in if I err anywhere along the line here. So this is a motion for reconsideration to the board's petitions that have been approved, I believe back in October of 2025. At this point in time, I'll ask the petitioning party to add anything that he wants. We have your motion written motion you provided. I ask you to provide anything more that you need to elaborate on. I'll ask Mr. Swartz. I know we have an objection to these petitions, Mr. Swartz. We have some feedback from somebody that maybe not be muted. Everybody check their connection. Sure.
Mrs. Cooper, I think it might be coming from your line.
Let's try now. Yeah, that took care of it. I believe you've got an objection to this motion, and I'll ask you if you have anything you wish to elaborate on, and I'll give you a chance to respond. After we do that, go through that process, the board will consider each of the items that have been outlined in the petition. We'll try to elaborate on those and refer back to our original decision as needed. Ms. Cooper and the staff will be taking notes. We do have to file a written response to this petition. We'll probably take a recess. We'll review those notes, and then we'll come back in and take our vote on what we decided to do based on their discussion. Do we need another vote in there somewhere, Ms. Cooper? That may be the only thing I was confused about.
Yes, so the board will have a conversation about each of the points for Buchanan's, and then take a vote as to whether to approve, modify, or deny the motion. And then we'll take a recess. I will type up all the notes that you all mentioned, and then the board will vote whether or not to pass that written decision.
Okay. So there'll be two votes in here in this process, if I understand correctly.
Right.
Okay. Just make sure I got all that correct there. Okay, does anybody have any questions before we begin? Okay, Mr. Pewitt, do you want to elaborate any further on your motion for reconsideration?
Yes, sir. Thank you, Mr. Chairman. I'd like to address the surface rights element of my motion, first of all, with this brief explanation. You know from the evidence that the coal estate is owned by Buchanan Energy under their particular properties identified in these applications. And the surface estate is owned by Buchanan Energy in areas where the coal is owned. And in addressing the surface rights, we have to look at easement just a little bit, and I'll be brief here. But Buchanan Energy's coal rights are traced down to and ultimately to Coronado Coal. And Coronado has certain rights over Buchanan Energy's surface because it controls the coal. And those implied rights allow them to do what's reasonable and necessary to mine the coal. Legally, though, those are called appurtenant rights. Those rights over the surface are tied to the coal estate. Now, similarly, there is gas estate there that Virginia has ruled is separate and distinct from the coal estate. And Buchanan Energy owns that gas estate, and through various leases, or the gas lease involved, the rights over Buchanan Energy's surface to harvest that gas belongs to Diversified. And so we have two different appurtenant easements here. We have an appurtenant easement tied to the coal, and one an express easement and a lease tied to the gas rights. Now, the problem comes in with these applications because from the inception, these applications are for the purpose of harvesting gas. They're not primarily for the purpose of ventilation. we wouldn't be following these applications. So from the very inception, these applications are to harvest gas by a company that doesn't have access to the easement on the surface to accomplish that fact. Virginia law is pretty clear. If you have an easement on the surface that's tied to the coal, which Coronado has for the purpose of mining that coal, you can't reach up and take that easement and peel it away from the coal and apply it to the gas estate. That's an unlawful transfer. So the only easement over the surface for the harvesting of gas belongs to Diversify. And the granting of any applications that would allow the drilling through Buchanan Energy's surface for the purpose of harvesting gas would be a trespass. And the basis of our jurisdictional claim before this board was the board doesn't have jurisdiction to grant that easement or to decide whether or not it's a trespass. That right, that jurisdiction lies with the circuit court of Buchanan County in this case. That's the essence of the first jurisdictional claim. The second jurisdictional claim pertains to the lease rights themselves. We maintain that the act doesn't give the board the right to override the terms of an existing lease through forced pooling. Now, it's a correlative right that we're talking about here. And if you look at correlative rights as they deal with forced pooling, the board gives the right to forced pool owners to ensure an equitable sharing of resource. And correlative rights means, in essence, the gas and oil owner shall have an interest in a single pool, and they shall have a fair and reasonable opportunity to produce his just and equitable share. Equitable. Now, as my witness was cross-examined by Mr. Schwartz, it became apparent that the intent was to impose upon Buchanan Energy the standard lease rights through forced pooling, the standard royalty rates through forced pooling. When in fact, Buchanan Energy lease provides a better royalty position for the owner. In other words, they'll override the private contract that's been negotiated and in effect for 25 years through the forced pooling provision by giving them what they consider to be something equal to the unleased shares in the pool. Well, correlative rights talks about equitable shares, not equal shares. And the best illustration for that, and you may have heard this illustration, but it's three men looking over a fence. If the three men, if it's fair for them all three to see over the fence, they may have a problem because one man may be very tall, one of mid-size, and one man may be very short. So you give them all an equal 1 foot high box. The tall man doesn't need it. He can see over the fence now. The mid-sized man says, that's great. The short man still can't see over the fence. How does that apply? Well, in a pool, you have unleased shares that aren't cooperating in their pool. They're forced pool. They get an imposed lease upon them where they didn't have one before. And the law considers that fair. But then you have, or you may have, certain leased parties within that pool who had a better deal. And to make them whole, there should be a different royalty paid for them. They should honor the royalty of the existing lease. Now, that's the only way you don't override and take away from an established contract. You get an inkling of that under the objections by the coal owner. 45.2611. In Part C, it talks about allowable objections, and they include whether the decision will substantially affect the rights of gas operators to explore for produced gas. Well, okay. They're talking about a pool and co-owners' possible objections. But then in D, it says something that is an inkling of what we're talking about. And I'll read D to you. The factors in subsection C are not intended to and shall not be construed to authorize the director or the board under 45.2.1638 to supersede, impair, abridge, or affect any contractual rights or obligations existing between the respective owners of the coal and gas or any interest therein. The Act recognizes that there may be existing contracts that must be honored. And the enforcement of contracts is the right of the circuit court. We in both of these jurisdictional arguments ask the court to reconsider their ruling, which was really no ruling at all. The board simply in the decision acknowledged our arguments were made, that they had heard our arguments. But in awarding the applications under these circumstances, without making any decision as to the existing contract that Buchanan Energy has, and without addressing the surface rights that Buchanan Energy has, it really gives the authorization to go forward under those adverse conditions. Why? Because the applications that are filed by Pocahontas from their inception are for the harvesting of gas. Number one, they're not for venting coal, that's incidental. They're for the harvesting of gas. And there are uses of the surface involved in the harvesting of gas that aren't tied to the venting of coal. That's on the surface side. On the pooling side, it overrides an existing contract to do it in the manner Pocahontas seeks, which also we maintain is not allowed, improper use of the police powers by the board. Now, in the decision, the board took the position that Buchanan Energy's problems were solved by the opportunity to participate, which we've leased down to Diversified. And to address that, I would ask the board to consider something. At what point in time or at what point in scale does an artificially high cost of participation serve to chill the opportunity to participate? I'm talking about the phantom well costs that are tied to these applications. The evidence was pretty clear that there's a reimbursement that's made for those well costs. And the board in the decision argued that and found that those costs listed, and I would say, though not real, those costs listed were of the type and of the magnitude that we normally accept. That's a fair reading of the decision. I think a better decision, one I would ask the board to adopt, is truth in fact outweighs the normal expected cost. The board would have to take that position. I think they already do, because when someone comes before the board and they've got an unusually high well cost, the board says, why? Why are these costs that high? We've seen the board do that. We've seen the board turn people down for an unusually high well cost that they couldn't justify. But on occasions, maybe they can justify it. So if there is a standard, which the decision seems to indicate, that the board is going to accept a standard well cost for this type of expense, then why question it? Just apply the standard across the board. So we maintain the actual facts outweigh the customary cost. And in the case of Buchanan Energy's problems being cured by participation, which we gave to our lessee that right. But if the costs are too high, perhaps the lessee won't exercise that right. And really, this is a broader argument than just Buchanan Energy and Diversified. This talks about correlative rights of parties. What about a mom and pop operation? They think, hey, we can participate. We can do it on a carried basis, but wait a minute, these numbers are so high, we'll never get paid. I think the board has a duty to investigate this further. Now, the board chose not to allow us to discover, and I respect that. But the board has a duty to investigate, and if these costs are paid for and non-existent for the recovery of gas because they were paid for ventilation, they've been reimbursed, then that's a true cost. If they had a surplus put on there, they'd be before you asking for some additional consideration on the surplus. But what's especially troubling about this phantom cost is the fact that Pocahontas never mentioned it, and they never brought it before the board. And there have been a lot of applications approved where that's probably real. Now, you heard Diversified testify that, hey, we're gonna bring this cost forward, and we're gonna apply it and share it back with the owners. Now, that's fair. But we haven't heard that from Pocahontas. In fact, historically, we haven't heard that from Pocahontas. Same argument applies that we believe the board has a duty to investigate and should investigate that issue. It also applies to the destruction of methane. Heard evidence this morning about the destruction of methane. That directly affects the royalties received by Buchanan Energy. That directly affects the royalties received by every mom and pop within the pool. You know, in the mining companies for many, many years, technology caught up with the mining of coal, and they were able to mine coal seams that weren't mineable and merchantable in prior years. Isn't that really what's going on here? We've got a method of recovering gas that is weak gas. It's not the type that's normally marketed, but we have a method now through technology to recover for that. It's fair to ask where the royalties are going. Are we getting paid royalties on that? And that's something that we believe the board should reconsider and not simply say there's not enough evidence before us, but they should reconsider these applications and investigate. A very small issue was the barrier pillars and whether they were gas bearing. It's not clear to me, I'll confess to the board, it's not clear to me in the Gobwell situation whether considering those pillars as gas producing or not gas producing affects the royalties. The board didn't give any guidance in the decision either. That's why that issue's before the board. The main issues are jurisdiction that lies with the circuit court to decide on the surface rights. Jurisdiction that lies with the circuit court to not impair an existing contract on royalty rates, and the duty to investigate the what I call the phantom well cost and whether or not royalties are paid for destruction of gas. That's the essence of our motion to reconsider. We make it, and we appreciate the board listening. Thank you.
Thank you, Mr. Pruitt. You have your response, Mr. Schwartz?
Yes, I do. I'd like to start by quoting Casey Stengel. I feel like this is a deja vu again moment. We've heard all this before. I will try to be somewhat brief. The overall response I have to Mr. Pruitt's comments are he doesn't appear, or his client doesn't appear to have any concept of why Virginia adopted the 1990 Act, which allows forced pooling. Mr. Pruitt says that you shouldn't apply forced pooling to leased acreage. That was part of his argument we've just heard. The Buchanan has a 1.25% interest in unit G39. So basically 99% rounded of the gas that's going to be produced from G39 belongs to people other than Buchanan. But he's in here telling us that the Virginia Gas and Oil Act of 1990 doesn't allow this board to pool the 1% that would prevent the 99% owners from receiving any money. The 1990 Act was passed to prevent the tail from wagging the dog. We got a 1% owner here saying, you can't force pool this unit. I object to it. I don't want any revenue or any production from these 80 acres because I own 1% and I've leased it to somebody else. I mean, that's basically what he's arguing. And he's saying you can't force pool leased acreage. Well, the whole point of the 1990 Act was to allow you to force pool people who just said, I don't want you to produce my gas, to force pool people who said, I've leased my acreage to somebody else, or for whatever reason, collection of reasons. The 1990 Act was passed to allow people in the Commonwealth to produce coal bed methane gas and generate revenue from that, which you can't argue that that's a bad idea. But the fundamental approach that Buchanan and Mr. Pruitt takes here is you can't do exactly what the act was intended to do. You can't force pool us. So, this argument that they've leased it to somebody else and you can't force pool it is just flat wrong and is against the whole point of the 1990 Act. Then he's talking about surface rights. Okay, if we don't have an agreement with a surface owner, we can't go on their property. Clearly, we do not have an agreement with Buchanan. Okay, we don't intend to go on their property. We don't intend to trespass. We don't intend to have them sue us or give them an opportunity to sue us for trespass. We can produce from these isolated panel units that are at issue today without going on Buchanan's surface. So that is a total red herring. You don't permit wells. So, we would have to go to the division or the Division of Gas and Oil to get a permit, which we have done. But the question of surface rights has nothing to do here. I mean, we're not going to trespass and we don't need to trespass to produce gas from these. Actually, there are 3 panels involved in this collection of units. The units, the panels are the isolated longwall panels. That's the definition of them in Oakwood 2. Mr. Pruitt, talks about barrier panels and gas emanating from barrier panels. I mean, the gas in the isolated longwall panels comes from a number of places to the wells that the gob wells that terminate just above the gobbed area. They can come from the floor of the mine. They can come from pillars in the entries. They can come from a distance of maybe 20, 30 feet away of a barrier pillar. They can come from a lot of places. But the Oakwood 2 order says when you are paying on a gob well above an isolated panel, you calculate the acreage in the panel, not the panel plus the entries, not the panel plus barriers, the isolated panel, and you do the allocation for purposes of working interest, if people participate, for the purpose of royalty from the outline of the acreage within the isolated long wall panel. So, that argument misunderstands, again, the rules of the game. The acreage in the panels is how you calculate royalty and how you calculate the division of interest or working interest. Along the same lines, in terms of why is a mineral owner talking about some of this stuff? I mean, Buchanan, years and years and years ago, their predecessor in interest entered into a lease which has found its way into the hands of Diversified. Mr. Pruitt says that the terms of that lease are better than the 1/8 royalty terms that the board provides in its orders. Well, that's a gratuitous opinion, and I'm going to offer another gratuitous opinion. We've been provided with that lease, and I don't think it's any different than what the board orders. So, for what it's worth, I am not conceding that. I think that the Buchanan production lease, just like the board order says, you are to pay 1/8 of royalty on the value of the gas that you produce. Along the same lines, he's talking about carbon credits and flaring and destroying gas. We have testified point blank that we intend to produce this gas and sell it. We don't intend to flare it. And we're going to pay, and the order that we've submitted and it was entered here is the operator is required to pay royalty on the value of the gas you sell. I will point out that Diversified's order has the same royalty provision. They submitted proposed orders and they said, we're going to pay 1/8 of the value of the gas that we produce. So with regard to those issues in terms of, what's the purpose of the law? Who do you pay? How do you pay? It's just a fundamental misunderstanding of the rules of the game, the statutes that apply. In addition, this argument that Mr. Pruitt is making with regard to well cost makes absolutely no sense. These wells cost money. He's saying our well costs are apparently unreasonable. Well, Diversified has offered numbers for proposed well costs as well. They took our numbers and reduced them by 5%. There's a plus or minus 5% difference in the well costs between Diversified's costs on these units and ours. So to argue that our costs are unreasonably high is frankly ridiculous. We've been round and round and round about the reimbursement by Coronado. So what? Pocahontas Gas, CNX, was able to negotiate a favorable agreement when they transferred coal rights. It's their agreement. Diversified's not a party to that agreement. Buchanan's not a party to that agreement. We know what these wells cost because Diversified has validated what they cost, plus or minus 5%, and that's the participation cost. Buchanan does not have a right to participate in this unit. They've leased their their gas. Diversified has a right to participate in this unit as a working interest owner. Diversified's has filed recently papers with the board saying that they think they would have to pay roughly $2.8 million to participate in this collection of five units of the wells. They apparently have a difficulty doing math or understanding the board's orders because their number is about 300%. Their actual participation cost collectively in these 5 units, if they elected to participate in all of them, is less than $1 million. But it doesn't really pertain to Buchanan because Buchanan can't participate. They've leased their gas. They've given up the right to a working interest and retain a royalty interest. So, for them to be discussing well costs is just yet one more red herring, just like the surface rights argument. We're not going to trespass. They don't have an opportunity to participate as a working interest owner. Why are they talking about this stuff? Hard to tell. With regard to actually, I think that's about it. So let me check my notes real quickly here. Okay, so in summary, I think the board has spent an incredible amount of time on these units. I mean, we've been in front of you numerous times for many, many hours. You have met and considered this stuff with counsel for many, many hours. I really see no reason to revisit this decision to which you have devoted a lot of time and energy. And I respectfully request that you deny this petition for reconsideration. Thank you.
Thank you, Mr. Schwartz. Any final rebuttal, Mr.
Very brief. Mr. Schwartz misunderstands our argument about forced pull. If Buchanan Energy is forced pull, and their lease is in fact forced pull, our saying is don't upset the contract. We don't believe this board would upset the contract under the act. The contract being the payment of royalty, that is different because there are no downstream cost deductions from the royalty under the lease, where in fact they are under the board's implied lease for the unrepresented shares or the unleased shares. So we're not saying you can't force pull. We're saying you have to honor the contract that's in place, though, in doing so on the payment provisions. With regard to trespass, I believe that several of the proposed ventilation wells on F-37 and 38 are shown to be on Buchanan Energy's lease tract. And so to drill those wells, you don't have to trespass in the manner we.
I'm going to object to this. There's no testimony to support that in this record. And I can tell you, we are not going to drill wells on Buchanan surface without their permission, but there's no testimony with regard to those locations that you're talking about. You're just adding something here.
Well,
I object.
Mr. Schwartz, you've had your opportunity. We're going to take this short rebuttal and we can continue from there.
Right. The exhibit I've looked at here, which I think was put into record, shows the location of those wells, but I'll take Mr. Schwartz's assurance that they will not trespass on Buchanan Energy's surface at any point for the drilling of the wells. I wonder if he might also assure us that Pocahontas Gas will not earn any revenue from Buchanan Energy's property for the destruction of methane.
We have, Kelly has testified. You want assurance? Kelly has testified that we are going to sell that gas and pay royalty on the sales. It's in the record with regard to every one of these units. She's testified to that under oath. That's our plan.
Well, it has to be.
We don't need to hear any more
All right.
concerning that issue.
All right. Thank you.
Okay. So at this point in time, this is the opportunity for the board to express their details of the decision. It's not a time for the parties to interject. We'll have a discussion here. We'll go through each point. And then we'll make a decision based on that discussion. I'll try to, if everyone has a copy of the petition for reconsideration by Buchanan Energy, I'll try to reference each of the sections as we go through consideration. I'll try to summarize them briefly. I think we've heard quite a bit of information on it already. So item number 2 is a decision by item number 2 is related to the unmined barrier blocks and the production associated with blocks and how they affect the petition. I'll sort of interject my thoughts here, and then I'll ask the remaining board members to chime in with anything they want to add or clarify on those each of those. So again, a petition for pooling requires an estimate of potential gas production that is reasonable for a participating gas owner to consider in making an informed decision regarding an election option. The methodology that was presented in the Pocahontas gas application was deemed reasonable as an estimate. It's not a finite number. It's never going to be. This is a complex gas system. It's always an estimate, and that's an estimate that is utilized by someone making an election option. That's the purpose of that production number. Any other input from any other board members on this item?
Sir, I believe I understand.
We don't need any more introduction.
I just wanted to ask a question.
No questions.
Very good.
We're having our discussion here. This is our time.
Sure, sure.
So do we have any other interpretation that we made during the decision on that topic from any board members, including those board members who are online or remote attending out there also?
I have no questions. This is Bill.
This is Mary. The material I'm looking at is not numbered 1, 2, and 3. I probably don't have what you're reading from.
You should have received a copy of the petition for reconsideration from each of these parties today, Ms. Gibson. I skipped over 1. It was just a general parties and procedures and the way they labor things. It doesn't really matter what the numbers are. I'll give you the summary of what we're talking about each time.
Okay,
So
that's
you
great.
can
Thank
comment
you.
on that if you want to.
Okay. Okay. I have no comment.
So we'll move on to the next item on the petition for reconsideration, which generally outlines that Pocahontas is better suited as the senior operator within the coal mining longwall panel units and the drilling of the issue. And it talks about the rights of the surface and the subsurface. We've heard some information on that this morning again, and again, I'll project thoughts here. Ask again for the board to bring forth any other information. So again, a petition for pooling does not require the board to make a determination regarding surface or subsurface rights, nor does granting a pooling application grant any surface rights. The objecting party, a surface owner, retains that right to adjudicate any trespass claims in civil court. You also will have the opportunity during the permitting process. None of these wells will be able to be drilled during any of these units that have been pooled without a permit. That is a part of the permit process also. You can adjudicate that claim. Again, that has nothing to do with the petition for pooling. Any other comments from the board members that wish to interject on that item? Okay, hearing none, we'll move on. The next item on the petition for reconsideration is dealing with the rights of Buchanan, that believes that the rights of Buchanan and Diversified will be protected as required under Virginia Gas and Oil Act. Trying to just get to the crux of it here. I think it's dealing mostly with imposing a superior payment provision that then would be in a pooling application. So again, the petition for pooling doesn't require the board to consider the terms of the existing lease. The board is only required to establish a procedure for a gas owner to become a participating operator who can elect to sell or lease his gas or ownership to a participating operator or to enter into a voluntary agreement to share in the operation of the well at a rate of payment mutually agreed to by the gas and oil owner and the gas and oil operator. And again, the operation of this well as a non-participating operator can also be done under a carried basis. So again, any lease agreement that occurs between Buchanan Energy and Diversified is not affected by this. We're not usurping any rights there. If you believe you require a better payment option from Diversified, that's between you and Diversified, not between the board and you. Any other input from board members? Okay, we'll move on to the next item. The board today did not receive any direct evidence regarding the specific reimbursement structure applied to the dwelling units for Pocahontas and thus made no finding on issue. We've heard a lot again about that topic today. I'll interject again. The board determined that the specifics of any contracts regarding dwelling cost reimbursements were not germane to the petition of the pooling. The dwelling cost type presented in the petition was determined to be reasonable and customary within the industry standards and were calculated properly under the methodology outlined in the Oakwood 2 field rules. The board has no jurisdiction over Coronado Coal Company's reimbursement of costs to Pocahontas Gas as interpreted as a contractual matter. Again, if you feel you are being disparaged by that contractual relationship, the circuit court is the place to have that resolved. Other comments from the board? Okay, hearing none, we'll move on. The final item on the Buchanan Energy reconsideration is dealing with the environmental credit or carbon credits, however you want to term that, and use of those. Again, the petition for pooling by Pocahontas did not include any provisions for destruction of gas for the generation of carbon credits. The gas production is to be transported to a point of sale generated revenue subject to a royalty payment, provisions of the petition. Any downstream use of the gas for generating carbon credit revenue or any other type of revenue is beyond the scope of the pooling petition and the authority of the board. Any other comments from the board members concerning this item? Okay. I think we're at the point where the board needs to consider a motion on this reconsideration application. Again, the motion will either need to be to deny this petition for reconsideration, modify the case decision that we've already made, or vacate this case decision and have a new hearing. So I have a motion from any board member on how we would like to proceed with this petition for reconsideration.
Mr. Chair,
Yes, ma'am.
I would like to make a motion to deny this request. We already have a process for a resolution to this.
Thank you. We have a motion to deny. Do we have a second to this motion?
Second.
Have a
I'll
motion?
second, Mr. Chair.
Okay, we have a motion and a second. Ms. Gilmore, will you poll the board, please, on this motion for reconsideration?
Mr. Owens,
Abstain.
Mr. Sutherland,
Yes.
Mr. Cochran,
Yes.
Mr. Harris,
Yes.
Mr. Mullins,
Abstain.
Mrs. Gibson,
yes,
and Mr. Jansen.
Yes. So the motion for reconsideration has been denied.
Thank you for hearing.
Anybody need to take a break before we continue? All good?
Mr. Chairman, if we may have a brief break for me to
Okay,
write
sorry.
this up and send it to Sarah, who will send it to the board members, and
Okay.
have you all read it during the break, and then we'll come back and the board will vote whether or not to pass this written decision. I just need a few minutes to finish up summarizing and
Thank you for stepping in and remind me of that part of the process. So we will be taking a short break here and we'll come back when we have that document that we can again vote on. To adopt the written decision that we've just been provided by Ms. Cooper. So if I have a motion to adopt that,
Yep.
have a motion, do I have a second?
Second.
Okay, we have a motion and a second. Ms. Gilmore, will you poll the board, please, for approval?
Mr. Owens,
Abstain.
Mr. Sutherland,
Yes.
Mr. Cochran,
Yes.
Mr. Harris,
Yes.
Mr. Mullins,
Abstain.
Mrs. Gibson,
yes,
and Mr. Jansen.
Yes. Okay, so the board has denied that petition, and we move on to item number 8 on the docket. The board will consider objection, I'm sorry, let's see, I'm in the right place, number 7. Great. Yeah, that's it. The board will consider the objections to the decision and petition for reconsideration submitted by Diversified Production LLC, continued for the November 2025 hearing. All parties who wish to address this matter, please come forward and identify yourself.
Good afternoon, Ben Street for Diversified.
Mark Swartz for Pocahontas.
Okay?
Mr.
Again, we'll go.
Housekeeping only.
Okay.
May we have a copy of the order that's just been adopted for the record?
Yeah, that'll be provided.
Thank you.
We'll go through the same process that we did with Buchanan Energies, unless you want to withdraw it. Just a little bit. So again, I'll let Mr. Street begin by summarizing his motion.
Okay, well, thank you, members of the board. Nice to be back with you. I know it's been a long haul, but I appreciate you getting us on the docket today and listening to us. I'm not going to go through all the points, but I want to make myself available to answer questions or discuss with you. I feel like most of it's set forth pretty well on paper, but I invite your questions and comments, but I do have a couple things I want to mention. One is on the cost reimbursement issue. Mr. Pruitt in the last docketed matter mentioned that he felt like, or that his client felt like reimbursement had been established. We agree with that. I don't think that's the question. Question, I guess, is what consequence, if any, it has, but I do think that's important. There's several reasons why it's important, and I'll talk about some of them from our standpoint, but there's one today that has particular importance, and that is they're going to be cost reimbursed by Coronado. And what that means from just a cash flow standpoint is the current operator by order is Pocahontas. They're not going to actually have to spend any money on the wells in F-37 and 38 because they're going to get reimbursed by Coronado. So, and we're appealing these cases. Given those procedural facts, and with the election period coming up upon us, it does not seem necessary And with all due respect, it doesn't seem fair to make Diversified pay 1 million or 2.8.
This issue doesn't have anything to do with the petition in front of us. We'll hear that later.
Oh, no, I think it,
I don't think this has anything to do with the petitions that we've already heard. We have another motion from you that that will consider that.
well, I don't mind. Mr. Schwartz said this would moot that. It was my understanding that we would address this in the context of the reconsideration. This does deal with the costs, and it does deal with us asking the board to stay some or all of the orders. So I think it does fit in.
Okay.
And so when we get to that later point, I won't repeat everything. I'll bother you with the same wording, okay? So of course, what we want you to do is set everything aside and start over. I'm not going to jump into all that again. I'll answer questions, but at the very minimum, we do ask you to please amend or set aside the order in that respect, okay? We ought not to have to write a check for $1 million or $2.8 million. It's going to be on appeal. Pocahontas doesn't actually have any net out-of-pocket costs. They've admitted that to you. So that, given the unique circumstances of F-37, F-38, remember, my client owns like 82% of that. So we're going to have to cut a check for 82% of the total that they're not even going to have to pay while we go through an appeal. I don't think that's necessary. It doesn't hurt them to delay that. And so again, I want more, but that seems to me, and I didn't get into that as much in the motion at all in the motion, that aspect, but there's no prejudice to them to do that. So what I would suggest is you extend the election, either pause the election period or extend it, amend the order to pause the election period for 30 days to give us a chance to get ourselves in the appeal, get before the circuit court, and then we can address it after 30 days. It gives us some breathing room so we don't have to start sending money to Pocahontas Gas now. And you can do that through the motion to amend based on the cost structure, because this is unique. I mean, at least as far as I know, I don't think you've addressed reimbursed costs and the way that it affects this issue. So I did want to mention that. And I guess that's the only thing I really wanted to highlight for you on the motions to reconsideration. There are two. One of them was filed after the last set of orders, and that's why we continued it till today, so we could do them all at the same time. So I'm not going to go through all the different points. If this is an academically interesting case for me, and I've probably worn out my own friends and other lawyers talking about all this stuff, and I probably would be willing to do the same thing to you, but I won't. But if you have questions, I promise to be as succinct as I can with the answers, okay? So, of course, I do incorporate everything we've said in the motions for reconsideration, all of our prior positions and objections as well.
Thank you, Mr. Schwartz, do you have a response?
Yes, and I will just make a couple of points. I think the board understands my position on virtually all of this stuff, so I'm just going to ask you to assume that I am opposed to all of the grounds, all of the objections and alleged reasons for this petition for reconsideration. Obviously, you've heard plenty about reimbursed costs. I'm not going to cover that again. We've heard about carbon credits. We're producing and selling the gas. I'm not going to talk about that again. Unit F-37, we amended our petition. You mentioned that in your decision in October. One other point. Yeah, the last thing, trying to keep this brief. Item 14, and they've said this before. They appear to have a theory that frac wells automatically become gob wells. 14 says Diversified has frac wells in F37 and F38, and these wells will become gob wells. Well, that's not true. You have to file a petition, to be designated operator under Oakwood 2 to operate gob wells. From a permitting standpoint, frac wells do not become permitted gob wells without filing a permit application. So I would just point out that I think that is, they say they become gob wells, they clearly do not. I'm just going to assume that the board recalls, from all of the time we spent on these issues, our position, and I would respectfully request that you deny this petition for reconsideration. And the last point that I would make, since now we have a untimely motion to modify your orders to extend the election period and to stay and all this sort of stuff, we actually need to have a hearing on that. I mean, I think, I might want to call Coronado with regard to their mining and timing if we're going to be looking at a stay. So it's inappropriate to consider that today. The other thing on the stay or extending the time limits, I mean, they're seeking to modify 5 orders that you've already entered, and the terms of those orders. To do that, you need to notify everybody. Well, they haven't done any of that. They filed this a couple of days before this hearing. It's not appropriate to consider that today. I guess we'll eventually get to it and you'll make a decision whether it's not appropriate, but I just didn't want to respond to that. And that's all I have, Mr. Chairman.
Your final comments, Mr.
Yes, you're going to probably want to look at there's an amendment to the Oakwood orders and a couple of docket numbers. This is with respect to the issue of frac versus gob. We could call them frog wells, I guess, but here are the two docket numbers. These are from 1993. Docket number 93-0216-0336, and then 93-0316-0349. And if you look at paragraph 7, and this order, by the way, and also the order that we've talked more about, they make it clear that the Oakwood rules apply to a progression of mining before, during, and after gob wells. And so this is the provision that deals with how you treat wells that are in production prior to longwall mining. And it says, prior to the actual commencement of coal mining operations by the driving of entries and completion of isolation of a longwall panel. That's what we have. We have frac wells in F37, F38. We're prior to longwall panels. In that instance, you pay under the Oakwood 1 method. After the paragraph above that tells you what to do after the commencement of a longwall panel. And that's when you convert it over to the gob well formula. And I think if you ask your staff, they will tell you that that is the way it has been done. Operators of the frac well, once a gob well panel comes through, it is then converted to a gob. I'm not saying you don't have to file, something to modify your well permit to reflect that it's a gob well versus a frac well. But in terms of the rights to that well and how that well develops over time and changes during the course of the different mining procedures, these orders, and I believe your prior practice and procedures are all in uniformity with respect to that. And I'll also remind you that the original applications that Pocahontas Gas filed in these two cases, in F37, F38, they both conceded that we have frac wells there, and they both of those applications said when longwall panel mining comes through, those frac wells will be plugged and abandoned. And once they're plugged and abandoned, the old orders will drop away. Well, that's why they said that, is because if you don't do that, if that doesn't happen, we're still it. And so, of course, the evidence in the hearings contradicted that. In fact, there was no other evidence to contradict what our testimony was, and that was those wells will not be abandoned and plugged because they're still producing. They'll be converted over to gob wells. So that's that. I don't know if you want to. I think Mr. Schwartz might have been jumping ahead a little bit on the motion to stay, but I'll follow your lead on that. But that can be taken up with respect to this, which is on the table. It's been noticed. It's before the court, and that is the motion to modify the order, the orders and the decision that excuse me, to modify those things to give us a pause on having to pay that money. Thank you.
If I could respond to the 2 points that he addressed, the royalty issue and the plugging issue.
I don't think we need to have any more back and forth, Mr. Schwartz. I believe
Okay.
we're good to go, I believe.
All right.
Okay, so we'll go through the same process for addressing each of the points in the motion for reconsideration. And this is the board's opportunity to interject and express the details regarding the decision that was paid back in October. Again, I'll paraphrase each of the points here and take the lead on the response to those points. Again, referencing that we addressed a lot of these issues already in our original written findings from the original formal hearings. Got so much paper here.
Mr. Chair,
Yes, ma'am, Ms. Gibson.
I make a motion that we deny this petition for reconsideration based on the same reasons that we did number 7.
Thank you, Ms. Gibson. We do need to go through each item here and address them. There are more items in this reconsideration than the first one. So we'll walk through that again as quickly as possible, and then we'll have a vote. And we'll entertain the
Okay,
motion
thank
at that point in time.
Thank you.
Thank you. So I'm looking at the items 3 and 4 from Diversified's petition. These are generally dealing with the reimbursement cost. Again, that's the same response that we had in the prior hearing, where the board determined that specific of any contracts regarding the dwelling cost reimbursement structure were not germane to the petition for pooling. Dwelling cost type presented in the petition was determined to be reasonable and customary within industry standards and were calculated properly under the methodology outlined in the Oakwood 2 field rules. The board has no jurisdiction over Coronado Coal Company's reimbursement of costs to Pocahontas Gas. It is interpreted as a contractual matter. Again, if there's anything that other board members would like to interject into that discussion, this is your opportunity. And then we'll move on to the next item on the reconsideration. This was discussion regarding the boards going into a closed session with the board's attorney for discussion. Allegations there of maybe we did some things we weren't supposed to there. Again, the board entered its closed session to consult with its attorney regarding legal interpretations related to the evidence and testimony presented during the hearing as allowed by code. That's what we did, and that's what we adhered to when we went into closed session. So if there's any other discussion from any of the board members, we'll add that into a response.
Mr. Chairman,
Yes, sir.
are we going to receive a call-in number for the closed session?
There won't be a closed session, Mr. Harris. Ms. Cooper
Okay,
is
we'll do like we
documenting
did.
their responses
like-
right now.
Yep,
We'll
okay,
have a-
I
we'll have a
understand. We'll do
recess.
this.
We'll do it
Yeah.
just like the last one. There will be a recess while
got
we generate that written document.
Okay, got it. I think you mentioned closed session. That's why I asked. Okay, yes, I'm happy.
Okay,
Thank you.
thank you. Yeah, the closed session was referring to the closed sessions that we did during the formal hearings.
Yes, okay.
The next item in the reconsideration is generally dealing with the environmental credits, or carbon credits. And again, that's the same response as the last reconsideration. The petition by Pocahontas Gas did not include any provisions for destruction of gas for the generation of carbon credits. The gas production is to be transported to a point of sale, generating revenue subject to the royalty provisions of the petition. Any downstream use of the gas for generating carbon revenue or any other type of revenue is beyond the scope of the pooling petition and authority of the board. Again, I'll ask board members for any additional input on that item. None, we'll move forward again. Item number 7 is also dealing with the generation of carbon credits. Again, Diversified did present testimony of its intent for the destruction of gas for the generation of carbon credits and was questioned by the board. But since that petition presented did not include any of those provisions, that petition for cooling by Pocahontas Gas did also not include any provisions for the destruction of the gas. So there was no consideration there. Either party addressed that in either application. Any other input from the board? Next item in the reconsideration request by Diversified addresses the decision not to have an informal fact-finding conference prior to the formal hearing. And again, the board elected not to hold an informal fact-finding conference based on the recommendations from the Attorney General's office. They're based upon recommendation of the interpretation of the Administrative Processes Act under section 45.2-1618, which governs the board. Formal hearing conducted by the board allow for sufficient testimony and evidence to be presented on parties from all parties for the board to make an informed decision. Again, if there's any other input from the board members, please acknowledge. The next item in the petition for reconsideration by Diversified address the official matter regarding the application for unit F-37, where there was a error in the notice on the map. Was a track that was identified. It was not listed in their application. However, the notice issue identified in that Pocahontas Gas petition for unit F-37 was rendered moot since the party associated with the unidentified track was also notified of the proceedings under its ownership in another track within the same unit. So they got notice. We decided that was not a huge issue there. Any other input from the board? The next item in the reconsideration is also dealing with the well cost and the reasonable and customary, and whether these are reasonable and customary within the industry. And again, the drilling costs presented in the petition were determined to be a type of reasonable and customary in the industry standards and calculated properly under the methodology outlined in the Oakwood Code rules. Again, the board has no jurisdiction over Coronado Coal Company's reimbursement for Pocahontas gas, interpreted as a contractual matter. Hearing no other input. The next two items, 11 and 12 in the petition, are dealing with, I think what this is dealing with is the designation of the Oakwood Field rules and designated a single unit operator and how that was accomplished by the board. So again, the board relied upon the Gas and Oil Act regulations and the Oakwood 2 field rules when designating a single unit operator would be best suited to develop gas production in a series of 80-acre units associated with the coal mining operations of the longwall panel. The Virginia Code under section 45.2-1602, section 1, provides that the Virginia Gas and Oil Act shall be liberally construed, firstly, to foster, encourage, and promote the safe and efficient exploration for the development, production, utilization, and conservation of the Commonwealth's gas and oil resources. In light of the board's mandate to uphold efficiency and cost development, and due to practicability and capability concerns surrounding the gas production of multiple operators in one drilling unit, the board found that Pocahontas was better suited to be the operator with the coal mining longwall panels at issue and also the drilling units at issue. A lot going on in those two, so if there's any other input from the board, hear that at this time.
Mr. Chair, I didn't hear your last comment.
I was just asking for any additional comments from the board members, Ms. Gibson.
Thank you.
The next item in the reconsideration motion deals with how units like Diversified's F-37, I believe that's F-38 maybe, are to deal with the various methods and phases of production of CBM in conjunction with the mine development and how that revenue allocation is accomplished. Again, the board interprets the Oakwood 1 and 2 field rules as containing the various methods and phases of CBM gas production that were utilized in making that determination. The next item on the reconsideration is Diversified has CBM well units and units F-37, F-38. Those Diversified wells will become God wells under the aforementioned orders. Diversified as operator. We've heard some input from both parties today regarding that. The CBM frac wells in units F-37 and F-38 would be mined through, requiring the bottom hole plug to be accomplished in the Pocahontas number 3 coal seam by the coal mining longwall operation, eliminating this portion of the gas contribution to the well. In other words, there would be no gas would be allowed to flow from the mine up that wellbore because it'd have to be plugged under current regulations addressing mining and gas production. The wells could continue to produce and operate under the Oakwood One rules. However, historically, wells in Long Old Pass have been adversely impacted by mining operations, including wellbore stability and gas production, and have generally been voluntarily plugged to the surface, eliminating the potential liability of a difficult, costly plugging process also required by regulation. Any contractual relationship regarding the plugging requirements between Coronado Coal and the unit operator are again beyond the scope of the board's pooling order. Anything that the board wants to interject, this is your opportunity. Last item in the petition for reconsideration by Diversified was regarding the concept of short hole gas production. So the Diversified petition, a main rule there. Diversified's petition indicated short hole gas production, but no testimony as evidence was presented on how that gas production would be achieved operationally, resulting in an efficiency. Pocahontas Gas has routinely collaborated with Coronado Coal Company to collect and meter short hole gas production, facilitating the revenue distribution to its gas owners by utilizing its own gas pipeline network at the designated coal mining air shafts. I think that addresses everything that was in the petition for reconsideration. And again, the board's approval of Pocahontas Gas pooling petition can also be appealed to the circuit court. In addition, any lease or contracts that are subject to disputes between Buchanan Energy, Diversified Energy, and Pocahontas Gas can be adjudicated in a civil court setting within the appropriate circuit court. Does anyone else have anything to add to a response to the motion for reconsideration?
Could I ask a question? I didn't understand everything you said a minute ago. When you were addressing number 15, did I understand you to say that there was no evidence, or that there was, or I just couldn't hear you completely.
What I said was that the petition by both parties included that they would be producing that short hole gas.
Representation.
And there was a representation there that we done. However, Diversified did not discuss that in their application. The board relied on its past knowledge of applications similar type from Pocahontas Gas to how they would achieve that. It wasn't addressed by Diversified. So again, at this time, the board will consider a motion to either deny the petition for reconsideration, modify the decision that we've already made, or vacate this decision and have a new hearing. So I have a motion. I think I had a motion earlier from Ms. Gibson. Do you want to restate your motion at this time, Ms. Gibson?
Yes, sir. I do make a motion that we deny this request for reconsideration.
A motion denied. Do we have a second?
I'll second that, Mr. Chairman. Bill Harris.
Thank you, Mr. Harris. We have a motion and a second. Ms. Gilmore, will you poll the board, please?
Mr. Sutherland,
Yes.
Mr. Cochran,
Yes.
Mr. Harris,
Yes.
Mr. Mullins,
Abstain.
Mrs. Gibson,
Yes.
and Mr. Jensen.
Yes. The motion for reconsideration has been denied by the board. Okay. The next item on the agenda, the board will receive an update of the board and division
Excuse me,
activities from the staff.
Mr. Chairman, sorry.
Yes. Oh, I'm sorry, we have to recess. I'm sorry. We have to
Please take
recess
a
for a written
recess.
decision.
Yeah, thank you. Sorry about that.
There was a supplemental motion for reconsideration. Do you want to,
We'll handle that on item number 9.
oh, that's 9. Okay.
So we'll take another brief recess while we generate the written decision that the board will come back in and vote on. Ms. Thornton. Give everybody back. Okay, I think we're ready to proceed now at this point. So the board members have all been provided the written decision regarding the reconsideration by Diversified and had a chance to review that. So at this point in time, we'll entertain a motion to accept this written decision, or if it needs further edits.
I'm sorry, I couldn't understand your last few words.
I
We
was
need
just
to,
saying,
do we need to make a motion? I'm sorry.
yes, sir. We need a motion at this point to accept the written response to the request for reconsideration, or do we need further edits or any further discussion?
Okay.
This is Mary Gibson. I make a motion that we accept the notice as written.
Thank you, Ms. Gibson. Do we have a second?
I'll second that, Mr. Chairman.
Okay, we have a motion and a second. Ms. Gilmer, will you poll the board, please?
Stay.
Mr. Sutherland,
Yes.
Mr. Cochran,
Yes.
Mr. Harris,
Yes.
Mr. Mullins,
Abstain.
Mrs. Gibson,
Yes.
Mr. Jennings.
Yes. So we've, that concludes the information required under item number 8 for docket. And we'll move on to item number 9. Board will receive an update from board vision activities from the staff.
Yes, Mr. Chairman, I do have time to bring this for the board. We received a motion to extend or stay the elections deadline that was spelled out in the October 23rd hearing. And that was submitted by Leonard Head, December 11th by Ms. Allerger. And also dealing with that, it was submitted only 4 days. We got it on 12 days. The board meeting had 4 calendar days. Which that was not defined along with the timeliness of submitting a new petition for the board. So therefore, your board petition should be 30 days in advance of the hearing. And there's a reason behind that, you know, gives all parties the opportunity to proper notice and have the opportunity to make their arguments for the case. So, you know, I make a motion to the board to either dismiss the order of the petition, or Mr. Streetman's argument, we have option to withdraw it. Or come back, we continue to fix more wishes.
You have an option of whether you'd rather to continue this to the next board hearing or whether just dismiss it.
I do. Can I respond to the underlying motion first, or just want to?
Most of them can't really be heard. It's either one time.
It's sort of up to you. Do you,
I'm
I'm going to withdraw it, or do you want us to vote on it? I guess is the question.
Well, I have an alternative method where you would have the power to do that. So let me, if you don't mind, I'll tell you what that is. I'll be quick.
Okay.
So a couple of points. One is, are you talking about the motion to stay or the?
Yes, motion.
Okay, not the supplemental reconsideration?
No, talk about the motion to stay.
Okay, all right. So to do that, in order to get 30 days notice for that to hit today, we would have had to file that before we ever received the orders. So the point in time that we received the orders was on November 18th. And had we filed the motion to stay the moment we got the orders, we wouldn't have 30 days. So it is an impossibility for us to have accomplished what Mr. Skarupa wants us to have done for this meeting. And so because of that, and given, I promise you I wouldn't restate it and I won't, but given what I described earlier about the payments and so forth, the board has the power and the jurisdiction, separate and apart from a motion or petition initiated by me, on its own motion can amend an order. And you can do that pursuant to a regulation, which is 25-160-150B3. And that motion says all orders issued by the board under 1619 of the code shall remain in effect until vacated or amended by the board on its own motion. It goes on to say, unless otherwise provided in the board order, all orders issued by the board under 45.21020 shall remain in effect until vacated or amended by the board on its own motion. So the board on its own, separate and apart from what we have done, can take that action today. And I respectfully suggest you should, because there is no way, it is absent the bending of time, there's no way we could have filed a 30-day motion to stay prior to this hearing, because we didn't get the orders until November 18th.
Okay, thank you.
Mr. Chairman, say something.
Yes, sir.
Disappoint you on the reason I have an issue with the time list. If you look at the Form BAC 25-160-30, it definitely specifies that you petition shall be filed at least 30 days prior to, and this is a new petition. It was untimely. Well, it really can't be heard. It's untimely. And whether you continue, withdraw, that's another question, or the board dismisses.
Ms. Cooper, would you like to weigh in on this issue also for direction for the board?
Yes, so, on 2 points, on Street's point about the final order, I think everyone can recall that as part of the application process, a proposed final order was submitted alongside the application documents. And the board, in its written decision that it filed and dispersed to the parties on the October decision date, said that order was going to be enacted. The Pocahontas proposed order, that is, was going to be enacted as is. So the other point to which Mr. Skarupa touched on was the code section for filings. I'll pull it up right here. It's for VAC 25-160-30. It says applications to the board must be filed within the 30-day deadline. So it's not a may provision, which states that any request for board action must be received by the division at least 30 calendar days. So if the board decides to take up or entertain Diversified's motion, they're bound by that must language requiring it to be filed at least 30 days before. And I will say, in addition to that, there are serious concerns when something is filed, very close to a deadline. It doesn't give other parties fair notice. It doesn't give any of the other people that were listed in the final order notice to come to this hearing today and to either state their support or their opposition to amending this deadline. It doesn't give opposing counsel much of a chance. It doesn't give the board much of a chance to wrap their brain around it. So all those things are things to consider. Mr. Street is correct. If the board wishes to take up its own motion, it certainly has the power to do that under for VAC 25-160-150. So the board has that power, but in regards to Mr. Street's motion, the 30-day deadline is a requirement.
Thank you, Ms. Cooper.
Mr. Chair. Go ahead,
Yes.
I'm sorry.
Go ahead, Mr. Yesom. I was just going to call for questions for discussion.
I just have a question. If he's wanting something on the agenda, right? Today? That we don't have any material on, don't know any of the details. I'm speaking from myself. No time to review any material as far as the board is concerned. Am I correct in assuming that's what he is wanting?
I think you are he's asking us to, I'm not sure how to word this, but he's asking us to overlook that fact today, that we have the power as a board to consider this today if we wish. So if I understand this correctly, we can either dismiss this motion, we can elect to continue it, or we can elect to hear it under not under the advice of our counsel at this point in time. The way the regulations are laid forward, we can do that, but that's not recommended. We have those two
Correct.
choices.
There's still notice issues if the board takes it on its own motion today. There's still issues regarding fair notice to all the parties involved.
Yep.
Yeah.
Mr. Chairman, I'm sorry.
Yeah.
Mr. Chairman, yeah, I'm also opposed to hearing it today. I think the notice issue has been well stated, and I think our two options are either to deny it or I don't know if it can be continued until January, where there's some issues about that as well.
I think Mr. Street would state that if we continue this issue, it becomes a moot point because his deadline for making the election option and payment will have passed, and he would have been deemed leased. So that continuing is a moot point, I think, at this point. So that's why we can either consider this, and we can continue it. I don't know what we'd do next month or the next hearing. It would be withdrawn at that point.
It would, things change in the world. I can't see it all, but it would most likely be mooted because yes, under the orders, I think we have to make an election this week at some point one day. So we find ourselves in a time box that we don't think we created because to actually request a stay under those orders, we had to get them. And then now we're all of a sudden past 30 days. So
I understand your concerns there, but I think you've heard this board state before too, that we went to this procedural process of receiving petitions and formal orders so that we could rule on those in one hearing rather than two hearings.
I think that's a good rule. I mean, and it's going to cover.
So you were on notice with that when that hearing took place that we approved it that day, whether you got the written finding or not. You knew what was happening on that day.
Well,
Is that correct?
Actually, the orders that you entered did not look exactly like the ones that were first filed. But that's really a side issue. We can't file a motion to amend an order or change it or suspend it until it's been entered. And so we can't. We just.
Let me put it this way. There may have been, and I don't know the specifics of what changed between the order that was filed and that. The elements addressing the election option, did they change?
Yeah, but
That's my question. Did they change?
I don't think so.
Okay, that's all I need to know. I think at this point in time, I'll call for a motion from the board on how we want to handle this.
Can I just respond to you? Because I know what your point is. And what I was going to say is your policy is a good rule in general. And it's going to work 99% of the time, but there are going to be individual unique instances where it's not going to be fair. And this, I respectfully suggest this is one of them because we could not get to you on this issue today with 30 days notice and we're boxed in time wise. So it's a very unique instance.
I agree. And I might consider this differently, and this may not be the right way to address this, but Diversified is a large corporate entity with a lot of resources. I'm not going to dispute that. I don't see that it is a hindrance to that company if they want to elect in this, participate in the well, to put that money up this time. If something changes in the past, they'll get their money back. So it's a matter of money changing hands. That's something we can't control here today. But if you want to participate in the well, I think under the terms of the order that's been issued, you've got to meet those deadlines. That's my opinion. And the other board members can step into that for discussion also.
So
So again, the board operates under a motion. So if someone wants to make a motion to dismiss or continue this request, we'll entertain a vote on that motion.
I make the motion to deny.
To dismiss the motion. Okay, do I have a second
Yes, sir.
on that motion?
I'll second it, Mr. Chair.
Okay, thank you. Ms. Gilman, will you poll the board, please?
point of discussion. I don't think the board has the jurisdiction to dismiss it. I think even assuming it's an application, which we don't concede, and assuming it's incomplete, which we don't concede, if it is an application and it is complete, I think under your rules, you have to continue it to the next date.
Negotiating with the board after it's made a decision is not appropriate. We need to be done here.
Thank you, Mr. Ford. Ms. Cooper, just if you want to weigh in on that last point, I think that this could be, you have time to file for the next hearing if you want to file it again, refile it under the proper guidelines. Is that correct?
Yes, if you would.
I think the
wish us
30
to-
days is Friday, maybe.
Yeah.
Yeah.
So if you want to place it on the docket for next month, you can still do that.
But are you suggesting we refile it completely or just?
I think that would be the procedure. It would need to be refiled as a,
It would be, if I may.
if we
Mr.
deny,
Chairman,
if we're voting to deny it today,
It'd be a new petition.
it'd be a new petition.
You may want to look, Ms.
Yeah,
Cooper,
if I may, yeah. So you would deny hearing it today under the regulations. If this is if the board agrees this is a complete, application is what they call it, but asking the board to do something. A complete application that is not filed by the deadlines of the subsection shall be carried over to the next scheduled meeting of the board. So you would deny hearing it today, and it would be placed on the next regularly noticed docket if that's something Diversified
Okay.
wishes to do.
Ms. Gibson, will you amend your motion to that language, please?
Yes. But I'd like to have something clear on that. They still have to meet all the requirements of getting it on the docket for the next board meeting. Is that correct?
That would be correct.
Okay, then I make a motion that we deny putting it on the docket today, and they will have the opportunity to go through the procedure to get it on the docket next month.
And it would be
And
continued till,
yes.
that you, Mr. Harris, were you going to amend your second also?
Yes, I was going to say, yes, yes, that's what I was saying. I'll amend my second to accommodate that provision.
Okay, thank you, Mr. Harris. Now we can proceed with holding for a vote.
Thank
Harris,
Yes.
Mr. Sutherland,
Yes.
Mr. Mullins,
Abstain.
Mrs. Gibson,
Yes.
Mr. Cochran,
Yes.
Mr. Jansen.
Yes. Okay. Do we have any other report of business from the staff?
I do all the time, I'll do that, again already. January, so we can schedule a meeting and move it on. Third Tuesday of the month, that's what required.
Okay. So are there any questions concerning the procedural activities that will occur before the public hearing to be held in January? Questions from either party?
No, sir.
Mr. Schwartz, did you hear that?
I could hear people talking, but I really couldn't follow it. It was garbled.
So there's some
Sorry.
background voices coming in from somebody who's not muted. We'll try again. That we were just discussing the next month's hearing, where there will be the formal hearing on the petitions that were continued. If there are any questions concerning that. For everybody.
No, I understand. No, I understand that we're going to address the continued pooling applications in January as we planned at the last meeting.
One question I have that Ms. Cooper may need to weigh in on. I know we had a lot of difficulty at the last formal hearing where we were trying to elicit testimony remotely and had attorneys remotely. Do we have is there a requirement that we have to allow that, or can we require everyone to be present in person during that hearing, formal hearing?
I'm not entirely sure. I'll look that up real quickly. Eric, do you know off the top of your head?
I'll jump to your office and we'll confer real quick.
Okay, great. If we could have a moment to look that up.
Okay, thank you. Yeah,
Mr. Chair, I'm going to answer for council. So the law only requires the board to accommodate remote participation by non-members when the board is holding an all virtual meeting. But as in the entire meeting everywhere is virtual. So as long as you have a quorum of the board assembled in one physical place, the board can require individuals who are giving testimony or appearing to speak before the board to be present in that physical place.
okay, thank you. Do we need a motion to do that for this upcoming hearing, or is it just let the parties know, or how does that work?
That's a procedural matter that I think falls within the discretion of the chair to require. You know, it's your responsibility to it's your power to determine what proper order is for the board. It certainly never hurts to get anything done by motion, but I do think that falls squarely within the chair's authority to determine.
Okay, thank you. My inclination is, and I will solicit input from the rest of the board, that we do require everyone to be here present during this formal hearing. Does anyone see otherwise? I understand we may not have all the board members present next month, but we should have enough for a quorum in physical. If I understood you saying that correctly, that as long as we have a quorum, all the board members do not need to be here, correct?
That's right. The only people who have a right to participate remotely are board members under the electronic meeting policy. So they have a right to remote dial in if the requirements are met, such as having a quorum present in person and so forth.
Okay. Thank
I
you.
thought I understood you to say earlier that a quorum needed to be physically present.
We do. We
That's
need to
okay.
have four
All right.
physically present.
Mr. Chairman,
So
I need
yes,
to
a quorum does need to be physically present.
Mr.
But as long as there is a quorum physically present, members of the board can remote dial in as they have.
Thank you. Mr. Schwartz, you had a comment?
Yes, I am, because of my wife's health, unable to travel. So I understand that it is cumbersome to not have everybody in the same room. So if you adopt this rule, I'm not going to be able to participate in the hearing in January because I absolutely cannot travel. And I will confer with my client and, if they can get another lawyer up to speed, then that will happen. But I just wanted you to know you're not going to see me in person, unless a miracle happens in my life. And I just thought I'd let you know that.
Okay. Thank you, Mr. Schwartz. So given that piece of information, does anyone want to have any further discussion on this? Okay, we'll leave it at that for now, Mr. Schwartz, and you'll let us know what your client's position would be going forward. If we need to advise that, we'll do that, if for some reason.
Okay,
Mr.
so
Chairman, I'm sorry.
I guess,
Mr.
am I
Chairman.
to ask my client to find another lawyer and report back? Is that what you're asking me to do? I'm perfectly happy to do that, but I'm not sure what you're asking me to do.
I understand your position. You've made us aware of here today. So if we want to have all the witnesses present and all the attorneys present to proceed with these formal hearings, if you're not able to do it, you'll have to let us know if you cannot be replaced. Is that correct?
Okay, I cannot come in January, so I will then have my client find someone who can, and report back to you.
Okay, thank you.
Okay.
Did you have a question there, Mr. Harris?
Yeah, I was just wondering, had we made a determination that the council has to be there? I know we discussed about the possibility of that being made, but I don't recall hearing. Did you make that determination that next meeting we would have to have council present?
We would need to
I may
have
have
the
missed
parties
that somewhere.
for the formal hearing part of the next meeting. The board is requesting that the attorneys and any witnesses that are providing testimony to be present at the hearing.
Okay. Okay. I didn't know that was, I know we had said that we could make that determination. I just wanted to make sure that had been made.
Yes, sir.
Okay, thank you.
Okay. Any other updates from the staff to the board?
Unless Sarah has something that I think.
Okay. The final item on the agenda is the board review the November 2025 minutes for approval.
Motion approved.
Do I have a second? There a motion and a second. All those in favor say aye. Aye.
Aye.
Any opposed? No? Okay. Thank you. The minutes are approved. This concludes the December Virginia Gas and Oil Board hearing. Thank you, everyone. Just have a great holiday.
Thank you. You too.